Hello all. So today we are going to start our second session of ongoing series, which is Law Journal. This chapter number 3 Law Journal carries 10 marks of theory as per existing IBBI syllabus, and with effect from 1st July 2022 it will carry 9 marks of theory. So today we are going to discuss laws of contract, which is a very important topic out of this Law Journal. Normally minimum 3, maximum 5 or sometimes 6 marks of theory question may come out of this chapter only. So very easy to understand, but also interesting and very scoring. So this point number 1 and 2 we have already covered in session number 1. In today's session we are going to cover laws of contract, so in which we will talk about formation of contract, parties, voidable contract, various type of contracts, enforceable and contingent contracts, misrepresentation, fraud, effects thereon, and termination of contracts, remedies for breach, performance of contract, and we will end up this session with very important topic, which is indemnity and guarantee. So we will also do a comparative analysis between indemnity and guarantee. 1 mark theory question may sometime come out of this topic also. In subsequent session we will talk about remaining these topics, point number 4 to 12. So formation of a contract. Objective of Family Contract Act is to ensure rights and obligations of both the contracting parties should get honored. In case of failure to service the contract on any body's part, the aggrieved party can take legal course against the other party. The act is applicable in entire India except J&K. So this is the basic objective of forming a contract. The objective is to ensure rights and obligations of both the contracting parties. They should honor each other's rights and obligations. So these are the various steps which are involved in formation of a contract or execution of a contract. So first step is proposal or offer and its communication to the other party. Second step, post giving offer or proposal. And second step is promise, that is acceptance of proposal and its communication. I give you some offer and you accept it. That is second step number 2. Then third step is consideration, that is both parties get something. If you and me are signing a contract, both of us should get something in return of signing the contract. Then fourth step is agreement, that is an understanding or arrangement about promises and consideration between 2 or more parties. Offer and acceptance by 2 parties. So fifth step is contract, that is a specific agreement with terms and conditions that are enforceable in court. And last step is performance of the contract. So these are the essential elements of the proposal or offer, which is first step of the contract. So one person show his willingness to do or to abstain from doing something. Please note down, a willingness to do something or to abstain from doing something, that is not to do something, with an intent to obtain the assent of the other person. Essential elements of the offer proposal are, so basically I tell you that I will do something for you, right, and I seek your assent, I seek your permission. On contrary, I can also tell you that I will not do it for you, I will avoid doing for you, and I seek a permission for that thing. So that is, proposal can be of 2 types. So these are the essential elements of a proposal or offer. Offer must be communicated. We'll discuss all these steps, all these elements in detail in subsequent slides. Then offer constitutes willingness to do or abstinence to do some act. Offer must be made to other party. I cannot make offer to myself. Offer must be made with a view of obtaining the assent of the other. Offer may be express or implied. Offer may be conditional. Offer must be capable of creating legal relationship. The terms of offer must be certain. So first element is offer must be communicated to the offeree. Communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. For example, A proposes to sell a machine to B at a price of rupees 10,000 rupees. The communication of proposal is complete when B receives the letter. So I have told I want to communicate you offer. So till the time you do not receive that communication is not assumed to be completed. I have sent a letter to you. So I have sent a letter, that is not a communication. Till the time the letter has been received by you. Second element is offer constitutes a willingness to do something, some act or abstinence. So let us understand this thing with the help of example. So A says to B, I will paint a picture for you if you are ready to pay rupees 10,000 for it. Thus, this is an offer where A is willing to perform certain act for certain price. So this is for willingness to do something, some act. And let us understand the abstinence with the help of an example. For example, X says to Y, if you will pay rupees 500 rupees per month, I will not play tabla every night. This is an offer where X is willing to abstain from doing something for a consideration. Third important element of the offer or proposal is that the offer must be made to other person. An offer cannot be made by a person to himself. Please note it down. On the basis of fact to whom an offer is made, offer can be of two types. Number one, specific offer, and the other one is general offer. Specific offer is, what is it? Offer given to a particular person or a particular group of person. I offer you something or a group of people. That is a specific offer. And general offer is offer given to whole world. That is anyone having knowledge of its existence. So fourth element is offer must be made with a view of obtaining the assent of the offerer. Offer must be made with an objective to obtain assent of the other person. Offer is different from expression of interest or inquiry. Please note it down. Offer is not something which is similar to expression of interest or inquiry. Let us understand with the help of an example. Do you intend to sell your car? Is not a proposal but a casual inquiry. So if I ask you a question that do you intend to sell your car, that is not an offer, that is an inquiry. I may sell my car if I can get rupees 50,000 rupees for it. Again, it is not a proposal. Will you buy my car for rupees 50,000 rupees? This is a proposal, as it has been made with the objective of obtaining assent of Y. Please note down that the offer may be express or implied. Section 3 of Indian Contract Act provides two modes of communication, an act and omission. So first mode of communication is an act and second mode of communication is omission. Let us understand both these two things in upcoming slides. So what is an act? Expressed by oral words including telemessages. So act, as per the section 3 of Indian Contract Act, an act is defined as, or act is what? Expressed by oral words, which includes telemessages also. For example, A says to B, will you buy this car for rupees 80,000 rupees? So it also includes expressed by written words. So first is oral words including telemessage. Second is written words like letters, telex, advertisement, etc. For example, A writes a letter to B, will you buy this car for rupees 80,000 rupees? This is an act. And then expressed by conduct, including positive acts or signs so that other person understands what the person acting or making signs mean to say or convey. It is also called implied offer. For example, the best runs buses on different routes to carry passenger. Best is a Bombay local bus department, public transport department. So the best runs buses on different routes to carry passenger at a scheduled fares. This is an implied offer by Best. So Best doesn't give that local transportation company doesn't offer ticket price to everybody. So they have their buses, their routes are fixed, their prices are fixed. So it is an implied offer. So by way of conduct, they are giving an offer, when they are signing a contract with the passengers. So under this section 3 of Indian Contract Act, an act is defined as by oral words, by written words, or by conduct. Please note down, 1 mark 3 questions sometimes come out of this slide only. Then the second part of this thing is omission. Omission would not mean silence, but would include such conduct or forbearance on one's part that the other person take it as his willingness or assent. Let us understand this with the help of an example. For example, A says to B, I will leave 80% of my property for you if you will not drink alcohol till I am alive. B, who was fond of drinking alcohol, doesn't say anything but abstain from drinking alcohol. So that is nothing but B's acceptance is conveyed. Right. So let me repeat. You are fond of drinking. I tell you that I will give you 80% of my property if you do not drink till I am alive. So you do not say anything to me. You do not say yes or no to my offer. But you stop drinking. You abstain from drinking alcohol till I am alive. So that is, it is presumed that you have conveyed your acceptance to my offer. That is omission. Sixth element is an offer may be conditional. An offerer may attach any terms and condition to the offer he makes. In such a case, it can be accepted only when the condition is fulfilled. It is immaterial if the terms are hard and ridiculous. Please note down. For example, let us understand with the help of an example. For example, A gives an offer to B to sell his car for rupees 80,000 if he sends his acceptance by telegram immediately on receiving the offer. So I have given you offer. I will sell my car to you subject to condition that you give your acceptance to my offer through telegram only immediately after receiving my offer. If B sends letter of acceptance instead of telegram, the offer stands cancelled subject to offerer informs the other person about cancellation of offer on account of non-compliance of terms condition stipulated. Say for example, you give your acceptance to me immediately after receiving my offer about selling the car, but not through telegram. Instead of telegram, you send a letter of acceptance to me. So as a I can intimate you that you have not complied with the terms condition. So the conditions are not fulfilled. So that offer is cancelled because of non-compliance of terms conditions stipulated in the offer. If offerer fails to inform the other person that he will not accept the acceptance because of non-performance of the condition by him, offerer becomes bound by the acceptance. So if I receive that letter of acceptance from your side instead of telegram, and I do not intimate you about failure of compliance of the terms condition which I had stipulated, and cancellation of the offer, so that offer is deemed to be presumed to be okay or accepted by me. You accept my offer, so it is considered to be okay acceptance. Offer must be capable of creating legal relationship. A valid offer must intend to create a legal relationship. That is, basic testing is intention of the party. If parties to the agreement have no intention to create legal relationship, it is not an offer in eyes of law. Let us understand with the help of an example. For example, X makes a promise with his wife, Y, that he will pay 1,000 rupees per month if she leaves her job, in writing with a specific mention that they want to be legally bound by it and it is enforceable in court of law. X and Y agree to contribute 1 lakh rupees each and start a partnership business with a specific clause in their partnership deed that any partnership dispute is not to be taken to court of law. The agreement lacks legal enforceability. So there are two examples. So in first example, legal relationship is there, but in second example, second example, partnership example, there is no legal relationship. So this is a contract, but this is not a contract. Terms of offer must be certain. A vague offer doesn't convey that what it exactly means. Thus, if one person offers to sell his car but forget to mention the amount, the offer is invalid. For example, if a person states that he is prepared to purchase the property for a reasonable sum, it is an invalid offer because amount is not mentioned, so it cannot be a valid offer. A promise to buy a horse from B. A promise to buy a horse from B if it is proved lucky. This is a vague and loose offer, and this cannot give rise to a contract. There is also a limitation to the rule number 8 or 8th element which we discussed in last slide. The rule that an offer is not valid if its terms are not certain can be ignored in following cases. If only minor term is meaningless, the same can be ignored and rest of the contract may be treated as binding. And if parties have had previous dealings similar to the present transaction, the courts can use these matters to ascertain the terms of the contract. So these are the two exceptions to element number 8 which we discussed in last slide. An offer must not thrust the burden of acceptance on the offeree. What is it? It is not mandatory for offeree to reply. I have given you offer. It is not mandatory for you to reply to me, to reply to my offer. The offerer cannot say that if the acceptance is not communicated within a specified or fixed period of time, the offer would be considered as acceptance. For example, A writes to B, I will sell you my horse for ₹500. If I do not receive a reply by next Sunday, I shall assume that you have accepted the offer. So this is not a valid offer. So if B doesn't apply, there is no contract as such. Please note now, this is a very important element of a contract. Now, after talking about various essential elements of an offer or a proposal, let us talk about a little bit about termination of offer. How an offer can be terminated. An offer can be terminated by notice of revocation, lapse of time, failure of the acceptor to fulfill a condition precedent to acceptance, failure to accept according to mode prescribed, death or insanity of the offerer, and by rejection. So 1 mark theory question may come out of this slide only. Cross offers. There is a difference between offer and cross offer. So let us understand what is the difference between offer and cross offer, how it is different from offer. If two persons make exactly same offer to each other at the same time without knowing that the other person has also made the offer, the offers are called cross offers. The cross offers do not amount to automatic acceptance. Please note down this line. If I and you are giving cross offer to each other, it doesn't amount to automatic acceptance. Let us understand this concept of cross offer with the help of an example. For example, A wrote a letter to B to supply 5,000 chairs at a particular price of a particular type. Then B wrote a letter to A offering 5,000 chairs of same type at same price. I wrote a letter to you that I want to sell you or deliver you 5,000 chairs of a particular make. You also writes a letter to me of same price, same make and same quantity. If they both are ignorant, you and me both are ignorant of each other offer, and both send their letter by post, you and me send our letters by post, so that the two letters crossed each other while in post. So before receiving the letters by each of us, the letter sent by us should cross in between while in the transit or in post. The letters are called cross offers. So that is a very good example to understand the concept of cross offer. To make the offer acceptance, either A has to accept B's offer or vice versa. Since they both made same offers to each other under ignorance, auto acceptance cannot be assumed. And there is one more concept of counter offers, which is different from offers or cross offers. Let us understand. If offeree does not accept the offer and instead his offer to the original offerer, the new offer, is called counter offer. I gave you offer, you do not accept my offer. Instead, you give me another offer. So that new offer that you give me is called counter offer. So there is a hairline difference between cross offer and counter offer. Never get confused. You know, theory question may come out of this cross offer counter offer question slides. Once counter offer is made, the original offer is dead and can't be accepted unless renewed. So I gave you some offer, you did not accept my offer, but instead you give me another offer. So that new offer is called counter offer. The moment you gave me another offer, the original offer expired, is assumed to be dead. So let us understand with the help of an example. Mr. A offers Mr. B to sell his horse at rupees 1000. Mr. B replies to A that B can pay 800 rupees for the horse. B's reply is a counter offer and A's offer is dead. A's offer of selling the horse at 1000 rupees is dead now. When counter offer is made by the offeree, following situation may arise. The offerer, Mr. A, refuse the counter offer, then there is no contract. No contract will happen. If the offerer accepts the counter offer, then contract will be formed. Mr. A accepts the offer of 800 rupees given by Mr. B, which is counter offer, then contract will be formed. And third scenario could be the offerer refuses the counter offer and renews his original offer and send it to the offeree. Now offeree accepts the original offer, then contract will be formed. So when Mr. A receives counter offer of rupees 800 from Mr. B, Mr. A can refuse this 800 rupees of counter offer and can give another offer of say 900 rupees to Mr. B. So if now Mr. B accepts 900 rupees of offer, then contract will be formed, otherwise contract will not be formed. There is one more concept of invitation offer. It is different, again different from offer proposal. The purpose of invitation to offer is to merely inform and circulate the information that he is willing to deal with anybody who on such information is willing to open the negotiation with him. So it is mere information or circulation of information. Invitation is often is nothing but circulation of information. It is different from offer. Please note down. In case of offer, purpose is to obtain the assent of the other party. But here no assent is being made. Let us understand with the help of an example. If I park my car on driveway of my house outside with a board of for sale notice on it on the windscreen, I put a for sale notice on my car's windscreen, and I park that car outside my house with a board on it for sale, then it is an invitation to offer. It is an open public information I have given to public that I want to sell this car. Now anybody can come and negotiate with me for the price of the car. Now next step is acceptance. So these are the important essentials or essential elements of an acceptance. Acceptance must be absolute and conditional. Acceptance of offer means acceptance of all terms conditions attached to the offer. I gave you some offer. You have to give me unconditional acceptance. Any conditional acceptance has no meaning. Acceptance must be conveyed to offerer through the mode desired by the offerer. If you remember in one of the examples wherein I gave you to sell my something subject to condition that you have to give me your acceptance through telegram, but instead of telegram you send me a letter of acceptance. So you did not send me your acceptance through the mode desired by the offerer. So it must be conveyed, acceptance must be conveyed to the offerer original if I give you the offer through the mode desired by the offerer only. Acceptance cannot precede the offer. I cannot accept a future offer. I cannot give before the moment I receive the offer. Prior to receiving an offer, I cannot give my acceptance. I will accept all your future offers. Acceptance may be implied or expressed. Acceptance must be given within a reasonable time, that is before lapse or revocation of the offer. So it is important. Then acceptance must be by an ascertained person, offeree. Only offeree can accept the offer. If I have given you offer, you are offeree, then only you are the person who can accept the offer. A person going on the road cannot accept my offer because I have not given any offer to him or her. Offer once rejected is dead and cannot be accepted without renewal by the offerer. So I have given you an offer, you did not accept my offer, you gave me counter offer, or you rejected the offer. Once it is rejected or you gave me the dead counter offer, my original offer is dead. Now you cannot say that you had offered me that price, so now I accept it. Please remember this thing. So once it is counter offer is made or offer is rejected, so original offer is presumed to be dead. Silence doesn't imply acceptance. This is also an important element of acceptance. Consideration. It is a return benefit to both the parties. It has following legal elements. Consideration should be for both formation of contract or agreement and discharge of contract or agreement. Please note this point, very important. Consideration may be past, present and future. Consideration must be positive or negative. Consideration must be done at the desire of promisor who makes the promise. Consideration may be furnished either by a promisee, party to whom promise is made, or any other party. Consideration must be lawful, real and not illusionary. Consideration need not to be adequate. So there is no concept of adequacy of consideration. Consideration must not be the performance of existing duties. And last, consideration must be of some value in eyes of law. Now, after understanding proposal, acceptance and consideration, let us discuss who is competent to sign a contract. This is again a very important topic. 1 mark or 2 mark theory is must. Question is must out of this topic. So any major person having sound mind and is not disqualified from contracting by any law can sign a contract. So following cannot sign a contract: minor and person of unsound mind. Let us discuss these two points in detail in subsequent slides. Who is a minor? A contract signed by minor does not have any value in eyes of law. Please remember this thing. As per Indian Majority Act, a minor is a person who has not attained 18 years of age. However, in following cases, a person becomes major on completing the age of 21 years. It is very important slide. 1 mark theory question normally comes out of this slide only. It's confusing a little bit. 18 years and 21 years. So please remember. So normally it is 18 years, but however in following two scenarios, person becomes major after attaining age of 21 years. So what are these two scenarios? Where a guardian of a minor's person or property has been appointed under Guardian and Ward Act 1890. So if this is the scenario, then a person becomes major on attaining 21 years of age, where superintendence of minor's property is assumed by court or ward. Now, what if majority guidelines are different in two land of laws of two persons signing the contract? You and me signing contract. You hail from India and I hail from Sri Lanka. So different two countries are having different guidelines for a person to be assumed as major. So for example, in India, age of majority is 18 years. However, in Sri Lanka, age of majority is 21 years. If a person of 20 years age sign the contract, following rule shall apply. This is also another very important slide, out of which 1 mark theory question may come in the form of case study or small example. In case of contracts relating to ordinary mercantile transaction, the age of majority is to be determined by law of place where contract has been made. So in case of mercantile transaction which are of mercantile nature, so age of majority to be determined by law of place where contract has been signed. If the contract has been signed in Sri Lanka, then age of majority for both the signing authority signing persons will be 21 years. However, if the contract is being signed in India, then age of majority for both the persons is 18 years. In case of contracts related to land, the age of majority is to be determined by the law of the place where land is situated. So if you and me are signing a contract, you are from India and from Sri Lanka, and the property is situated in Sri Lanka, then we both should be of age more than 21 years, whether we sign the agreement in India or Sri Lanka. Likewise, if the land is in India and we are signing a contract in Sri Lanka or in India, then age of the both the person should be more than 18 years to make that contract effective or legal. Persons of unsound mind. A person with unsound mind at the time of signing of agreement is not competent to enter into a contract. So at the time the agreement is being signed, that time the person should not be of unsound mind. The unsoundness may be permanent or temporary. Please remember this line. Unsoundness may be permanent in nature or temporary in nature. Maybe somebody has consumed alcohol or drugs or some anything, charas, gaja, anything he has consumed. So a person should be of sound mind, and it could be temporary or permanent. An unsound person is not capable of understanding and forming rational judgment. There is a logic behind which a person of unsound mind cannot sign a contract. Free consent. This is also an important concept. When both parties agree to a thing in the same sense of mind or unison of mind, please remember these three words, it is called free consent. Definition of free consent, please remember. A consent is not free when caused by coercion, like gunpoint, undue influence, fraud, misrepresentation, and mistake. So if any contract is being signed under any of these four circumstances, those contracts are called voidable agreements. And if contract is being signed because by mistake, it is called void agreement. So we'll discuss void and voidable agreements in next two to three slides with examples. So there is again a very important concept: void agreements and voidable agreements. And this coercion, gunpoint, many times 1 mark theory question out of it come. So if any agreement is signed out of coercion or gunpoint, then that agreement is voidable agreement and it is not a free consent. Void a contract. A contract which ceases to be enforceable by law is called void contract. Please remember this definition of void contract. Very, very, very important. A contract which ceases to be enforceable by law. Void contract is not enforceable in the eyes of law at all. This contract at the time of entering may be valid and binding on the parties. It may subsequently become void. The contracts signed by parties by mistake are void. Next is voidable contracts. A contract which is enforceable by law. Void contracts were not enforceable by law, but here the contract is enforceable by law but can be cancelled by agreed party within reasonable time is called voidable contract. Once rejected by the agreed party, the voidable contract becomes the void contract. I and you sign a contract. Let us we'll understand with the help of example also. So typically voidable contract include coercion, undue influence, misrepresentation, and fraud. I discussed in previous slides also. A contract made by a minor is often voidable by minor only. So if I am minor and I sign a contract, so I can make that contract void. Minor can void the contract till minority and for a reasonable time after he or she reaches the age of majority. So if my age is 16 years, I have signed a contract, I can make it void till I attain age of 18 years or under few circumstances 21 years, as we discussed in the previous slides. So or after a certain time after I attain the majority, so till that time that contract is voidable. So once I cancel the agreement, then it becomes void. After lapse of reasonable time, after attaining the majority, the contract is deemed to be ratified and cannot be avoided. So after I attain age of majority, which is 18 years, 21 years under a few circumstances, now the contract is deemed to be valid. Thus, a voidable contract may be considered valid if it is not cancelled by the agreed party within a reasonable time. So please remember. Next is classification of various contracts. Contracts can be broadly classified into three main categories or bases as under. First category is legal effect basis. Second classification is based on performance basis, and third classification is based on the basis of formation. So let us discuss all these three set of classification in detail. Legal effect basis. Valid contract. First type of contract as per legal effect basis is valid contract. It has all elements of contract and is enforceable by law. Void contract. Contract which ceases to be enforceable by law. It is not enforceable by law. Voidable contract. Contract which is enforceable by law but can be cancelled by agreed party within reasonable time. Illegal contracts. These are void ab initio and are forbidden by law, or defeat the purpose of law, or involve injury to a person, property of another, or court regard it immoral, or opposed to public policy, or fraudulent. So if any of these three elements are available, then that agreement is void ab initio. Please note on that all illegal contracts are void, but all void contracts are not illegal. Please, very important line. 1 mark theory question sometime comes out of this line only. And then fifth is enforceable contracts. It is a contract if a contract is otherwise good, but because of some technical defect can't be enforced by law, is called unenforceable contract. These contracts are neither void nor voidable. Please remember this line also. Second set of classification is based on performance basis. Executed contracts and executory contracts. So what is executed contract? If both the parties have performed their respective obligation, the contract is called executed contracts. If one or both parties to the contract are yet to perform their respective obligation in future, it is called executory contract. It can be of two types: unilateral executory contract and bilateral executory contract. So unilateral, one party has to perform, as name suggests, one party has to perform in future, other party has performed his obligation either in past or at the time of signing the contract. And bilateral, both the parties perform their obligation in future after signing the contract. Third classification is based on basis of formation. Express contract, implied contract, quasi contract. Quasi contract also called pseudo contracts. So express contracts are terms of contract are expressly agreed upon in words, written or spoken, at the time of formation. And in case of implied contracts, terms of contract are inferred from the acts and conducts of the party or from the circumstances of the cases. And in case of quasi contracts, these are automatically created by law. Quasi contract is based on principle that a person shall not be allowed to enrich himself at the cost of another. These are strictly not contracts, as there is no intention parties to enter into a contract. It is a legal obligation on the parties to perform certain obligations. These are also called pseudo contracts. Let us see an example of pseudo contract also. So this is an example of pseudo contract. If Mr. A orders a pizza and the pizza gets wrongly delivered to Mr. B, if B accepts the pizza, B is legally bound to pay as under. In case pizza company delivers another pizza to Mr. A, B gets entered into quasi contract with the pizza company to pay pizza MRP to the pizza price to the pizza company. I ordered one pizza. That pizza got delivered to your residence. Now the pizza company gave me another pizza. Now you have to pay the pizza fees to the pizza company. It is obligation on you. In case A doesn't get his pizza and has made online payment, so I ordered the pizza, I made payment to pizza company. Pizza company delivered that pizza by mistake to your residence, and now pizza company is not giving me another pizza. So now you gets into a quasi contract with me to pay the amount. After quasi contract, there is another form of contract which is called contingent contract. It is also called conditional contract. Performance or non-performance of these contracts depends upon happening of some event. These events are collateral to such contract. That is future uncertain event. Let us understand this type of contracts with the help of an example. For example, Mr. A agrees to sell his house to Mr. C, subject to condition that B refuses to buy it. So then the contract between A and C is called a type of contingent contract because it depends on a condition that B refuses to buy it. Now, after having fair understanding about various types of contracts, let us understand how a contract can be discharged. What are the various modes or methods through which a contract can be terminated, or contractual obligations of both the parties under a contract can be discharged, can be terminated. So discharge of contract can happen via either of these 6 modes: discharge by performance, discharge by impossible performance, discharge by mutual agreement, discharge by lapse of time, discharge by operation of law, and discharge by breach of contract. So let us discuss all these 6 modes in detail one by one in upcoming slides. So first mode of discharge of a contract or contractual obligation of both parties is discharge by performance. When parties to a contract perform their respective obligation under the contract, the performance may be actual or attempted. Please note down, the actual performance could be actual or attempted. So in case of actual performance, a party when actually fulfill all his obligations under the contract. Actual performance brings the contract to an end. For example, Mr. A enters into a contract with Mr. B to sell his car at 80,000 rupees. A delivers his car to B and B pays rupees 80,000 to A. Here actual performance has been taken place, so contract is being discharged by performance, actual performance. So attempted performance, in this case, in case the promisor shows his willingness to perform or tender to perform, however the promisee refuses to accept it, the promisor gets discharged from his obligations mere by showing his willingness to perform. Let us understand this concept with the help of an example. For example, Mr. A enters into a contract to sell his car to Mr. B. Mr. A offers to deliver his car to Mr. B, but B refuses to accept the car. It is nothing but tender of performance by Mr. A. By offering the car, Mr. A has completed his part of promise. So Mr. A is discharged from the contractual duties obligations by doing the attempted performance under the contract. Discharge by impossible performance. When performance of a contract becomes impossible to perform due to factors which are beyond control of the parties, the contract stands automatically discharged. So there could be 2 scenarios under this thing. Number 1, where impossibility is existent at the time of making the contract, where or the impossibility may arise subsequent to the formation of the contract. So let us discuss about first scenario, where impossibility is in existence at the time of making the contract. So these type of contracts are void from their inception as such because performance is impossible to do. So following are the various alternative situations in this context. Fact of impossibility known to both parties. So at the time of execution of contract, the performance was not possible. It was impossible to do the performance, and at the same time, the fact that impossibility of performance is known to both the parties. For example, contract to discover a treasure by magic. Such a contract is void. Fact of impossibility known to one party. One party is aware of the fact that such performance is not possible, but other party is ignorant of the fact. This contract is void in case the ignorant party suffers any loss because of non-performance of the contract. Former party is liable to make good the loss. For example, Mr. A, who is already married, again married to Mr. B, Miss B, without B's knowledge of this fact. So as per Hindu Act, second marriage is forbidden. Here contract is void. However, Mr. A is liable to make compensation to Miss B for non-performance of the promise. So fact of impossibility unknown to both parties. When both parties are ignorant of impossibility of the performance at the time of contract, the contract is void for mutual mistake. Let us take an example. For example, Mr. A is not knowing that his horse is dead, but he contracts to sell it to Mr. B. The contract is void. So there could be three scenarios. Both parties are having knowledge of the impossibility of the performance. One party is having knowledge of the impossibility of the performance and other party is ignorant. And both the parties are ignorant about the impossibility of performance of the act. Where impossibility at the time of signing the contract, the performance may not be impossible, but it may become impossible after signing the contract, subsequent to signing of formation of the contract. At the time of signing the contract, performance is possible. However, because of happening of some future event, the performance becomes impossible. Then the contract becomes void. The contract becomes void due to subsequent impossibility only if the following conditions are satisfied. So the act should have become impossible or unlawful. So all these conditions should get satisfied to be qualified under this point. So first condition is that the act should have become impossible or unlawful. Number one, factors causing the impossibility should be beyond control of both the parties. That is second condition that should be get satisfied. The impossibility should not be self-induced. That is, should not be due to negligence or default of any of the parties. So all three conditions should get satisfied to be to fall under this category. There could be various scenarios which cause impossibility of performance. So like destruction of subject matter. For example, Mr. A gives his music hall to Mr. B for a concert, for a live concert, and the hall gets destroyed by fire. Now Mr. B cannot perform his concert because the hall has been has already been burnt by fire. Now both Mr. A and B are free from their respective contractual obligations because of the contract becomes void due to impossibility of performance due to outburst of fire in the hall. Failure of ultimate purpose, death or personal incapability of promisor, a change in law or government policy rendering future performance illegal. For example, contract to purchase a timber from B which is to be imported by B. In case the government bans import of that timber, subsequently the contract between A and B tends discharged after the change in law by government, as import of timber is now illegal activity. And then there could be outbreak of war also. For example, an Indian firm signs a contract with Chinese firm to export 1 lakh ton of groundnut. After signing and before execution of the contract, China declares a war against India and the agreement becomes void because both parties are discharged under the contract. Next is discharge by mutual agreement. The parties make new contract to discharge or modify the obligation of one or both parties. The Contract Act provides three modes of discharging original contract. So this is also an important, these three terminology: novation, alteration and recession. So 1 mark theory question may come out of any of these three terminology. So please try to clear these three terms very carefully with the help of examples. So novation, a new contract is being signed between same or new parties. Please remember these 2-3 keywords. This novation agreement, new contract is being signed between same or new parties or same or new terms. But consideration of the new contract must be discharge of old contract. For example, Mr. A owes ₹1,000 to B and B owes ₹1,000 to C. Now B asks A to pay ₹1,000 to C directly. So if A and C agree to it and sign a new contract, so this new contract will be called as novation. Contracts between A and B and C stands discharged. So in that case, so please note down these underlined words to keep track of, because examiner may give you an example and ask whether it is novation, alteration or recession. Second type is alteration. Here same parties. In previous case it was same or new parties agrees to new terms. In previous case it was same or new terms, but here the parties are same but terms are new. For example, Mr. A agrees to supply 100 bales of cotton to Mr. B on 9th August 2020. Later on, they mutually agree to postpone the date of supply to 20th August 2020. So this change amounts to alteration of contract and original contract stands discharged. Third is recession. So recession means cancellation. Recession may be expressed or inferred by the circumstances or conduct of the parties. It may occur in any of the following manners. When contracting parties mutually agree to cancel the contract. For example, Mr. A agreed to teach painting to Mr. B. Subsequently, Mr. A shifted to another city. Now, Mr. A and Mr. B mutually agreed to cancel the contract between A and B, between them. When one party fails to perform his obligation, the other party may cancel the contract without prejudice to his right to claim compensation for breach of contract. That is, the aggrieved party can claim damages from the defaulting party. For example, A agreed to supply goods to B on 7th July 2020 and B agreed to pay ₹8,000 on 25th July 2020. If A fails to deliver the good on 9th July 2020, B may cancel the contract and need not to pay on 25th July. So on this recession, both parties get discharged from their liability and B can claim damages suffered due to non-performance of the contract by Mr. A. Please note that a person breaking the contract cannot rescind it. In case of voidable contracts, the agreed party can rescind it. For example, Mr. A induced B to enter into a contract by undue influence. You might remember free consent. Here, law gives option to Mr. B to rescind the contract. If B chooses to rescind the contract, both parties are discharged from their liabilities under the contract. So fourth mode of getting discharged from contractual liability is discharge by lapse of time. Every contract has a limitation period and contract must perform within the limitation period. Please note down this fact. So in civil matters, limitation period is 3 years. For example, Mr. A sells good to Mr. B at a certain price. Mr. A doesn't demand payment for the same. After lapse of 3 years from the date of sale, Mr. A cannot go to court to demand his payment from Mr. B. Next mode of discharging contractual liability is discharge by operation of law. A contract can be discharged by operation of law under following 4 scenarios: death, insolvency, merger, unauthorized material alteration. So let us see death. In case of contracts of personal nature, death of any of the party discharges the contract. For example, A agrees to paint a picture for B. If A dies, the contract is discharged. Next is insolvency of any of the parties involved in the contract. An insolvent person gets discharged from all his liabilities incurred prior to his such adjudication. The rights and liabilities are transferred to an official assignee appointed by the court. For example, Mr. A borrowed ₹5,000 from Mr. B. Subsequently, court declared him insolvent. Mr. A is being declared as insolvent. Now, Mr. A is relieved from paying ₹5,000 to B. Merger. When an inferior right enjoyed by a person gets merged with superior right enjoyed by the same person, the inferior right gets vanished, and this is known as merger. Thus, obligation constituted by inferior right is discharged. For example, a man holds property under lease. Subsequently, he buys the property. Now, his right to as a lessee vanishes because it gets married with the right of ownership which he has now acquired. For example, I have taken a property on lease. Subsequently, I purchase the same property. So my right as a lessee in the property get vanished because now I am owner. So ownership rights are better than superior rights than the lessee rights. That is why. So lessee rights will get merged into superior rights, and contractual liabilities in the form of lessee get discharged. Unauthorized material alteration. When one party makes alteration to material terms in the contract without consent of other party, both parties get discharged. I and you have a contract. I or you, either of two of us, make some material alteration, alteration of material terms in the contract. So both of us will get discharged. It gives same effect like cancellation of document. A material alteration is one which changes the legal effect of the instrument, or is one which alters its legal character or identity. Clerical, please note down here. Clerical mistakes are immaterial alterations and do not lead to any change in contract. Last mode of getting discharge of a contractual liability is discharge of breach of contract. So breach of contract means failure of a party to perform his obligations. A breach can be of two types: actual breach or anticipatory breach. Let us understand each one of two. Actual breach is what? When a party fails to perform his obligation on due date or during the performance. Further, if a party performs his obligation but not strictly according to contract, under all 2-3 scenarios, it is called as actual breach of contract. In case of actual breach of contract, the aggrieved party may rescind the contract and can claim damages from the other party. In case the defaulter party performs or offered to perform his obligation at a date later than the due date, whether the delayed performance lead to breach of contract or not, it depends on fact whether time is essence of the contract or not. So let us understand this concept of time of whether time is essence of the contract or not with the help of some examples in upcoming slides. So time as essence of contract. If time is essence of the contract, the aggrieved party can rescind the contract and claim damages. For example, Mr. A agrees to sell and deliver 100 gallons of oil to Mr. B. Mr. A delivers only 200 gallons of oil on 9 July 2020 without indication of the date when the balance oil will be delivered by Mr. A. Here, Mr. B can return 200 gallons of oil and rescind the contract and also sue Mr. A for the damages. Right, so please try to understand. So under this case or example, time is essence to the contract. That is why Mr. B can cancel the agreement and claim for damages and return a part delivery of the item. In case time is not an essence of the contract, for example, if time is not essence of the contract, the aggrieved party cannot rescind or cancel the contract but can claim damages due to delay performance. For example, A promises to supply 200 fridges to Mr. B on 9 August 2020. Mr. A doesn't supply the fridges on 9th August, sorry, but delivers on 10th August 2020. So there is a delay of 1 day. B cannot refuse to accept the same because there is no time, here in this case, time is not an essence to the contract. Since time is not an essence to the contract, but can claim compensation from A if any for delayed delivery. So since fridges have been delayed by 1 day, so for that Mr. B can sue Mr. A to seek compensation for the delay. Anticipatory breach: if one party by words or conduct refuse to perform or disable himself to perform his obligations before the due date, it is called anticipatory breach. It can happen by following: express breach by spoken or written words, when one party communicate other party about his intention not to perform before due date. So before due date, I explicitly, by speaking or by writing words, written words, I tell that I will not do any, I will not perform my duties or obligation. For example, in March, Mr. A gives a contract to Mr. B to put a sewer line in June. On 10th April, Mr. B tells to A that he will not do the job. So it is an express breach. Implied breach, where a party by his own voluntary act disable him from performing the contract. For example, A agrees to marry Mr. B, but before due date, A marries to Mr. C. This is an anticipatory breach by A, and B is the agreed party, and Mr. B can sue Miss A or Mrs. A in this case. So next question arises that what an aggrieved party can do in case of anticipatory breach. So in this case, aggrieved party can treat the anticipatory breach as actual breach and sue the other party before waiting for due date of the performance. It's like in case of sewer, in March, I and you signed an agreement that I will put a sewer line in front of your house in June, and in April I informed you that I will not do that work job for you. So I need not to wait till June. I can simply go in court and sue you, right? You can sue me, sorry. So the aggrieved party may decide to ignore the anticipatory breach and opt to wait for the due date of performance. Here I repeat, the aggrieved party may decide to ignore the anticipatory breach. So I refused you that I will not do your job. So you cannot sue me. You can wait till June. Okay, I'll wait till June, that whether I'll do, the other person will do the job for me. In this case, the aggrieved party carries the risk of contract being discharged in some other way prior to due date. For example, if it is a personal nature. So if I become insane or insolvent, or I die before the June, so then you cannot sue me. So that risk you are carrying. But if you want to wait till June due date, you can also wait, and post that you can sue me. Please note the doctrine of anticipatory breach does not apply to promises to pay money debt, such as those found in promissory note and bonds. Please note down these two lines because it's very important. Sometimes a 1 mark theory question may come out of it also. Indemnity. Now the last topic of today's session is indemnity and guarantee. So indemnity, it is a type of contract by which one party, promisor or indemnifier, promises another party, who is also called indemnified or indemnity holder, to save him from losses caused by the conduct of promisor himself, by the conduct of any other person. So this is indemnity, definition of indemnity, and these are the essentials of indemnity contract. All essentials of valid contract. So this indemnity contract should have essentials. So you should have characteristics of all the valid contract which we have discussed in previous slides. There must be a loss either by promisor or any other person. It must be expressed or implied. It is a type of contingent contract by nature. Liability of indemnifier commences when indemnified suffers some loss covered in the contract of indemnity. All contracts of insurance except life insurance are contract of indemnity. Please note down this line also. Except life insurance contract, all type of insurances are indemnity. Now let us discuss about various rights which an indemnity holder enjoys. The rights of indemnity holder are dependent on terms of the contract of indemnity as a general rule. Indian Contract Act 1872 states following rights to indemnity holder. So basically, as a general rule, actual rights of indemnity holder depends on the language of the contract of indemnity. However, there are certain general rights which indemnity holder enjoys as per Indian Contract Act, if otherwise some other terms condition is not stipulated in the contract of indemnity. So first is claim for damages. All damages paid by the indemnity holder in any court. Claim for cost of suit, cost incurred in filing the suit. Recovery of sums paid under condition of compromise. In case the parties agree to legally compromise the suit, the indemnifier has to pay the compromise amount. Let us understand with the help of an example. For example, X agrees to sell toasters manufactured by Y, and X also agrees to indemnify Y against any manufacturing defect. Say X sells a toaster to Z, any consumer or company which is Z, and now Z sues Y for manufacturing defect. There appears a manufacturing defect in the toaster, and the end user, consumer, which is Z here in this example, sues Y, original manufacturer, for the manufacturing defect. And because of this suit, the Y, original manufacturer, has to pay 10,000 rupees as damages and need to incur 1,000 rupees as suit file charges to Z, to end user. So since X had indemnified Y against manufacturing defects, now Y has right to recover 11,000 rupees from X. Rights of indemnifier. Rights under doctrine of subrogation. This we have already discussed multiple times in previous sessions. Subrogation. Indemnifier can sue third party for payment made to the indemnified indemnity holder. And indemnifier has a right not to compensate for losses not covered under contract of indemnity. For this doctrine of subrogation, I would request you to please go through this session on principle of insurance. There is a 1 hour session on the principle of insurance. There are various principles of insurance. One of the principle is subrogation. So this is similar to that principle. Guarantee. It is a contract to perform the promise or discharge liability of a third person in case default is done by the third person. Following are the three parties to a guarantee. So in case of guarantee, there are three parties: surety, principal, debtor, and creditor. Who is surety? Surety is one who gives guarantee. Principal debtor is one in respect of whom the guarantee is given, and creditor the person whom the guarantee is given. So these are the various essential features of a guarantee. So it has a tripartite arrangement or agreement. It is a contract signed among three parties, and accordingly three contracts get signed as under. First contract between principal, debtor, and creditor. Second contract between creditor and surety, and third contract between surety and the principal debtor. Liability. In guarantee, primary liability lies with principal debtor. Surety has secondary liability. Thus, contract between surety and principal debtor is also a type of indemnity. It also has all essential elements or features of a contract, valid contract. Guarantee may be either written or oral. Now this table gives us a better and fair picture about the various differences between indemnity and guarantee. So 1 mark theory question may come out of this single slide also. So in case of indemnity, there are two parties involved. However, in case of guarantee, there are three parties involved. So regarding privity of contract, indemnity doesn't have any privity of contract between surety and debtor. That is, third party can sue them. However, in case of guarantee, it is a mutual contract or has privity of contract among all three parties. So fourth party cannot sue or enter in the transaction. Liability of promisor. In case of indemnity, promisor makes himself liable and discharges his liability without reference to obligation of the third person. However, in case of guarantee, principal debtor is must. Agreement occur between surety and principal debtor. And who is defaulter? In case of indemnity, the liability may arise from loss caused due to conduct of promisor himself or by the conduct of any other person, third person. However, in case of guarantee, the obligation of surety depends substantially on principal debtor's default only. This is the basic difference between indemnity and guarantee. Thank you very much for watching today's little bit lengthy session, very interesting session. So before I am going to tell you what we are going to have in upcoming and next session, I would request you to please subscribe to this channel and click on bell icon so that you will be notified about next session, which I am going to upload soon within next 2 or 3 days. So now in upcoming sessions, we'll cover all these sessions. Most likely in next session we'll cover this tort, general principles of tort. There are 7, 8, 9 principles of tort which we will discuss in detail, also with the help of examples. And what are the effects of tort affecting valuation? So this is also another very important topic from examination perspective. At least one mark question is must out of this chapter. Then we will also discuss in second upcoming sessions law of arbitration, conciliation, the salient features, auctions, law of evidence, salient feature of Insolvency, IBC Act, Companies Act, then companies registered valuer and valuation rules, then SURFACE Act we will discuss, and Banking Regulation Act. Thank you.